I was 5 months into a deployment to Kuwait when my in-laws filed for emergency custody of my two children, ages 7 and 4, telling a family court judge that I had abandoned them and showed no meaningful interest in their lives. I found out about it 3 weeks after the hearing had already happened, from a friend back home who called me in a panic. By the time I heard about it, a temporary custody order was already in place. My children were living with my in-laws. And I was 8,000 miles away, unable to do a single thing about it in real time. I flew back on emergency leave the following week. My military attorney told me she only needed one piece of evidence for the next hearing. One video. Recorded months earlier, from a place my in-laws never imagined anyone would think to look. Welcome back to Kayla's Dark Truth. If you've ever had to fight for something that mattered most to you from far away, unable to defend yourself in real time, this one's for you. Comment when you get to the courtroom scene. That video moment gets me every time. And subscribe, because there's a lot more where this came from. My name is Captain Jennifer Ross. I'm 32 years old, and I serve as a logistics officer in the Army. I have 2 children, Mia, who's 7, and Noah, who's 4, from a marriage that ended in divorce about 2 years before this story takes place. My ex-husband, Tyler, and I shared joint custody, with the kids living primarily with me and spending regular weekends and extended holidays with him. It wasn't a perfect arrangement, but it worked, mostly because we'd both put real effort into keeping our children's stability separate from whatever resentment lingered between us. The complicating factor, and I want to be honest about this because it matters for what happened later, was my relationship with Tyler's parents, Harold and Diane. From the beginning of my marriage to their son, they'd made their opinion of my military career clear in 100 small ways. Comments about how a real mother would have chosen a career that let her be home every night. Questions about whether it was fair to the children that I sometimes deployed for months at a time. I don't think they were entirely wrong to worry about the difficulty of military family life. Deployment is genuinely hard on kids, and I've never pretended otherwise. But there's a difference between a legitimate concern and a years-long campaign to paint you as an unfit parent because your job doesn't look like the one they expected for their son's wife. When Tyler and I divorced, Harold and Diane's involvement in our children's lives didn't decrease. If anything, it increased, especially during my deployment windows, when they'd step in to help with childcare in ways that were genuinely useful and that I was, for a long time, grateful for. I deployed to Kuwait for what was scheduled as a 9-month rotation, supporting logistics operations for a broader regional mission. Before I left, Tyler and I had a clear agreement, put in writing through our lawyers as an amendment to our custody arrangement. The children would live with him during my deployment, with regular video calls scheduled twice a week, and Harold and Diane would help with after-school care given Tyler's full-time work schedule. For the first 4 months, that arrangement worked reasonably well. I had my video calls with Mia and Noah every week, sometimes interrupted by time zone issues or operational tempo, but consistent enough that I felt connected to their daily lives despite the distance. Tyler sent photos regularly. Harold and Diane, to their credit during this period, seemed to be genuinely helpful with the logistics of caring for 2 young kids while their father worked full-time. Around month 5, the calls started getting harder to schedule. Tyler would text that the kids were busy or already asleep more frequently than felt coincidental. When I did get calls through, they were shorter, and Mia in particular seemed subdued in a way that worried me, though I told myself it might just be the natural strain of missing her mom for months at a time. What I didn't know, what I wouldn't find out until weeks later, was that during this period, Harold and Diane had begun documenting what they characterized as concerning patterns in my parenting from a distance, building towards something I never saw coming. I found out about the custody hearing from my friend Priya, who I'd known since college and who still lived in our hometown. She called me on a Sunday, my time, sounding hesitant in a way that immediately worried me. "Jen, I need to tell you something, and I don't think anyone else is going to." She explained that she'd run into Diane at the grocery store, and Diane had mentioned, almost casually, that she and Harold had been granted temporary custody of Mia and Noah through family court, based on a petition alleging that I had abandoned the children during deployment and that Tyler was struggling to manage them alone without adequate support. I sat on the floor of the temporary housing unit I was staying in, 8,000 miles from my children, and felt something close to panic for the first time in my entire military career. I called Tyler immediately. He didn't answer for 2 days. When he finally did, his explanation was disjointed and, frankly, cowardly. He said his parents had handled the paperwork during a period when he was overwhelmed, that he hadn't fully understood what the emergency petition would actually claim, and that he'd essentially signed off on their version of events without pushing back, because it was, in his words, easier than arguing with them. The temporary order gave Harold and Diane primary physical custody of my children, based largely on a petition that characterized my deployment communication as sporadic and insufficient, framed Tyler as an overwhelmed single parent struggling without adequate support for me, and included several specific claims, including one alleging I had failed to send a single birthday gift for Noah's 4th birthday, which had happened 2 months into my deployment. I remembered that birthday distinctly. I had sent a gift, shipped through military postal service 6 weeks in advance specifically because international shipping during deployment periods is unreliable. I had video footage of the call where Noah opened it. I requested emergency leave immediately, citing the family court matter, and my command approved it within days. One of the genuine benefits of military family support systems, whatever their other limitations. I flew back to the United States 11 days after learning about the hearing. I retained a military family law attorney named Colonel Angela Vasquez, a JAG officer who specialized specifically in custody disputes involving deployed service members, a more common problem than most civilians realize, and one that federal law actually provides specific protections for, through something called the Service Members Civil Relief Act, which restricts courts from making certain custody determinations based on deployment status alone. Colonel Vasquez reviewed the emergency petition carefully and identified several problems immediately. The petition had been filed and the temporary hearing held without proper notice to me as required under the Act, given my deployed status. Several of the specific factual claims, including the birthday gift allegation, were demonstrably false and documentable as false. But Colonel Vasquez wanted more than technical procedural violations. She wanted to directly address the core narrative Harold and Diane had built, that I was a disengaged, absent mother who showed insufficient interest in her children's lives during deployment. "I need documentation of your actual communication pattern," she told me. "Not just call logs. Something that shows the court who you actually are as a parent, not just how often you technically checked a box." This is where the story gets specific, and I think it's worth explaining exactly what we found, because it wasn't dramatic in the way you might expect. No secret recording device, no gotcha moment. It was simpler than that, and in some ways more powerful because of how ordinary it was. Military installations, including the one I was stationed at during deployment, often have USO facilities that record and archive certain morale programs, things like message boards for deployed service members to record video messages home, particularly around holidays, that get uploaded to a public USO video archive as part of their broader morale and family support programming. I had recorded 3 separate messages during my deployment as part of these programs, one around a holiday, one for Noah's birthday specifically, timed to coincide with when I'd shipped his gift, and one general message recorded during a particularly difficult stretch where I talked, on camera, at length, about how much I missed my children and how central they were to every decision I was making during deployment. These recordings were publicly archived on the USO's own platform, timestamped, unedited, exactly as recorded. Colonel Vasquez requested permission from the court to enter one of them, the birthday message specifically, since it directly contradicted the petition's central false claim, as evidence. The follow-up custody hearing was held about 3 weeks after I returned stateside. Harold and Diane were present with their own attorney. Tyler was present, looking uncomfortable throughout, clearly aware by that point of how badly the situation had spiraled beyond what he'd originally agreed to. Colonel Vasquez laid out the procedural violations first: the improper notice under the Service Members Civil Relief Act, the failure to account for my deployed status appropriately in the original emergency hearing. The judge, a family court judge named the Honorable Patricia Wren, listened carefully, and I could see from her expression that these violations alone were serious. Then Colonel Vasquez requested permission to play the video. It was 2 minutes and 40 seconds long. In it, I'm sitting in a small recording booth on my base, in uniform, speaking directly to camera, saying happy birthday to Noah, describing the gift I'd shipped weeks earlier and hoping it arrived in time, talking about how proud I was of him for starting to read on his own, how much I missed bedtime stories with both kids, how counting down the days until I could be home again was what got me through difficult stretches of the deployment. It was timestamped publicly on the USO archive, recorded and uploaded 2 months before Noah's actual birthday, directly, undeniably contradicting the petition's claim that I'd sent nothing and shown no interest. The courtroom was quiet when it ended. I watched Judge Wren's expression shift from professional neutrality to something closer to visible frustration, directed, I believe, at the petition itself. "Counsel," she said to Harold and Diane's attorney, "your petition specifically alleged the mother failed to acknowledge her son's birthday. This video is timestamped and publicly archived 2 months prior to that birthday, and directly addresses it in detail." She paused. "I'd like to understand how that claim made it into a sworn petition." The attorney, visibly caught off guard, attempted to explain that the claim had been based on information provided by his clients regarding the timing of gift delivery versus the recording, an explanation that didn't hold up well under Judge Wren's follow-up questions. Colonel Vasquez used the moment to introduce additional documentation, my actual video call logs, which showed consistent twice-weekly calls throughout the deployment with only the expected disruptions from time zone and operational conflicts, directly contradicting the petition's characterization of sporadic contact. Harold, from his seat, interjected at one point, saying something about how the calls weren't the same as being there, which, while emotionally understandable as a grandparent's concern, wasn't actually the legal standard being argued and didn't help their position. Judge Wren, after reviewing the totality of the evidence, was direct in her ruling. She found that the original emergency petition contained material misrepresentations, that proper notice procedures under the Service Members Civil Relief Act had not been followed, and that the temporary custody order was vacated effective immediately. Primary custody was restored to the original arrangement, with the children returning to living primarily with me, given my post-deployment status, with continued regular time with Tyler under the original custody agreement. I picked Mia and Noah up from Harold and Diane's house 3 days after the ruling. I want to be honest that this wasn't a triumphant, dramatic reunion in the way you might picture from the outside. Both kids had clearly been affected by months of confusion and disruption. Mia especially, at 7, was old enough to have absorbed some of the tension around what had happened, even without fully understanding it. It took months of consistency and stability to help both of them feel settled again. My relationship with Harold and Diane has not recovered, and I've made peace with the likelihood that it never fully will. I don't allow unsupervised time between them and my children anymore, a boundary that Colonel Vasquez helped formalize as part of the final custody order. Tyler and I had a difficult, necessary conversation about his role in allowing the situation to happen, and while our co-parenting relationship survived it, it required real repair. I completed the remainder of my deployment about 4 months later, having used the rest of my emergency leave carefully, coordinating with my command to ensure I could return to complete my rotation while my children remained stable at home with a support system that no longer included unsupervised time with their grandparents. I used to think fighting for your children meant being physically present every single moment, proving your devotion through constant proximity. Deployment forces you to learn a harder truth, that love and presence aren't always the same thing, and that sometimes the people who question your commitment the loudest are the ones who never had to prove theirs from 8,000 miles away. If you've ever had to defend who you are as a parent to people who decided the answer before they asked the question, I want you to know that the truth has a way of surfacing, even when you're not in the room to defend it yourself. Document everything. Trust the process. And know that showing up, even from a distance, still counts as showing up. That's my story. If you've ever had to fight for your kids while serving your country far from home, tell me about it in the comments. And if this one meant something to you, share it with somebody who needs to hear it today. Subscribe, and I'll see you in the next one.